Hearsay can be confusing sometimes, and in order to get a better understanding of it, you have to look at the definition of hearsay and also, I suppose, look a little bit at the purpose of the rules surrounding hearsay. Again, hearsay is considered as an out of court statement that's presented to prove the truth of the matter asserted. The last example that we gave, we were talking about Betty and her seeing aliens, or Betty saying that she saw aliens on the roof. Here's the thing, right? What we're trying to do is present a reliable statement to the jury. We want the jury to hear statements that are reliable. Have you ever played that game where you pass around from one person to another person, and by the time you get to the very end of the line, the statement is completely different than the one that it initially started out with? So rather than bringing a person who heard what Betty said, you would want to have Betty come to court herself. So if the goal is to convince everybody that there were aliens on the rooftop, and Betty is the person that saw the aliens on the rooftop, Betty needs to come and say, on such and such night at such and such time, I saw little green men or little gray men or whatever it is land on the rooftop, get out, do a tap dance, get back into their ship, and then they flew off. Betty would have to come to court and testify about that herself. So if Betty told Martha, and Martha wants to come to court and say, Betty told me that there were little green men on the rooftop, so I want you to believe it because Betty said it. Well, that's objectionable. That would be hearsay because it is a statement that Betty made while she was outside of court. And now Martha is presenting that statement to the jury, wanting to prove that what Betty said about the aliens being on the rooftop was true. That makes that hearsay, and it makes it unreliable in the eyes of the law. And we're trying to get the most reliable evidence to the jury that we possibly can. Generally, hearsay will be disallowed. Now, there are exceptions. There are also things that are considered non-hearsay, although they would appear to be hearsay right on the face of them when you first see it. Let's talk about a criminal defense case. You always hear about the defendant's words could be used against them. You would think, well, wouldn't that be hearsay? If it's a statement that's made by one of the parties to the lawsuit itself, that would be allowed. You can come in and say what one of the parties may have said while they were outside of court, and you are trying to present it to prove the truth of the matter asserted, which is why confessions in criminal cases would be admissible. One of the other things that you could look at is the example that I gave when I was trying to explain it, which is if you're not trying to prove the truth of the matter asserted, you don't want to prove that Betty actually saw little Martians on the rooftop. Martha instead wants to come to court and prove that her sister Betty needs a guardianship or something like that because Betty has mental health issues, apparently. She always thinks that she's seen aliens and ghosts. She just thinks all these weird and crazy things, and you want to prove that instead. So you would come to court and have Martha testify that Betty said she saw aliens on the rooftop. That would not necessarily be considered hearsay in that particular example because you're not trying to prove that the aliens were actually on the roof. You're trying to prove that Betty may need a little bit of help because she has mental health issues. So hopefully that explanation, going a little bit more into detail, helps you understand this better and helps people understand kind of why the hearsay rule is in effect. Hopefully you won't ever end up in a trial or a situation where testimony has to be given based on an issue that you're involved with. I'm attorney Marcus Sermons, and this has been another episode of Interesting Lawyer Stuff.